Host, guests, and callers, and not necessarily those of this station, its staff, management, or sponsors.
Welcome to Ask the Experts radio show, proudly sponsored by board-certified family law attorney Tina Lewert of Lewert Law, LLC. Sit back for the next half hour as host Steve-O interviews top experts in the fields of legal, health, financial, and home improvement. Steve-O offers such educational topics as community association law, family law, chiropractic care, employment law, healthcare law, and public insurance adjusting. Interviews by top experts in their field. And now, here's your host, Steve-O.
Hey, good evening, and welcome to another Ask the Experts. We're with you every Thursday night from 6 to 7. Tonight's the first Thursday of the month, and that means our great community association law show, K. Bender Rimbaum, and we've already got a board full of calls already. So I can't wait to get started. If you've got a question, please call us at 888-565-1470. It's 888-565-1470, and we got a ton of emails probably the last 2 weeks. Let me introduce you to one of the senior partners of K. Bender Rimbaum, Robert K. Good evening.
Hello, Steve. Hello, everybody.
I got to tell you, I think you've been with us for about 4 years. You also do our show in Tampa. We get more mail about your show. No females, just males, about your show. And people have actually said that you have helped them to when they go, they feel more educated when they go before the board to talk to them or people who are on the board. So you've gotten a lot of really great compliments. I want to talk about your firm first, but I've got someone here who's been holding for a while. So let's go to Dominic in West Palm Beach.
What? Yes. Good
Hello,
afternoon.
Dominic.
Yes, sir. Good afternoon or good evening. I have an important question that I have some confusion of. I have an owner, the husband passed away, and they went into probate, and after a year, it's finally in her name. And she would like to sell it to a family member. Now, in the past, we always had, say, the first right of refusal. There has been in the past where a similar situation where an owner sold it or gave it to his nephew. And I want to know if I, as, say, a president of the association, can allow this to happen. My understanding or thought process is that if someone owns an apartment and they don't want it no longer, and they have a family member that's willing to take it over, why does it have to go up, sell it? Why does that person have to notify the building or the association? It has to be posted for 10 days if they want to sell it to their family member because they're not interested in having it.
Well, the situation you described is going to be controlled by your governing documents in particular. Whatever provisions are in there for the conveyance of a unit, many communities have different provisions, but in general, they'll have a regular sale to a third party, and then they'll have a instance where there's a gift to a family member or a sale to a family member, whether or not that's part of the procedure of submission for application and approval from the association. It's all going to be specifically indicated in your documents. If your documents do not say anything about it, then the implication is that it's unrestricted and that they can do whatever they want with it without having to come to the association. So you have to look at your documents to see how they're written on this point.
Right. I did review my bylaws, and one of the amendments that's in there, because it's a 2-bedroom, and there are people that always want a 2-bedroom, and the association, we developed like kind of a seniority list, because someone that steps in tomorrow wants a 2-bedroom, but meanwhile somebody for 10 years or someone that's been there for 20 years, they want it. So the first right of refusal, like when I bought my apartment, it was bought from a stranger, and he had it on the market, and we had to post it for 10 days. So on the last day, I was able to get that apartment. But in our bylaws, it only states about the first right of refusal. It does not get into all of what you just mentioned, the third party and all of that. I want to do things the right way, but at the same time, I do understand that, like with my apartment, if I had a brother or a cousin who wanted my apartment, I think I'd feel that I do have the right to sell it to him. It's not that I want to post it for 10 days and they go back and forth with I want it and they want it. Hey, I feel that I have the right to sell my apartment to a family member. They have first preference. If it doesn't state like you said, then I hope that I'm in the clear, and I needed this advice because I want to make sure I make the right decisions.
Well, it sounds like your documents have a specific procedure for any conveyance of the apartments with the right of first refusal, and you have to follow whatever's in there. If you don't like what's in there, you can change that by the amendment process and having the owners vote
Right.
to change it to something more along the lines of what you've described.
Right. But it doesn't get into more detail other than we have the right of first refusal. And you have to post it. But again, if there's nothing else stated in there, then a family member can sell it to a family member, a blood relative, and, it's a family type of deal. She would like to give it to her niece. And I don't see where that's a problem.
It sounds like from what you've described that that's not something you can do, but again, I would need to see the documents to tell you fully, or your attorney should be consulted to give you more specific guidance on that. But generally, you need to follow your documents.
Okay.
Okay.
Thank you so
And
much, Dominic. So
Thank you for
we
your
have
time.
You're more than
and
welcome.
answering my question.
We have a
And
line
where
is he
open now
located?
at 888-565-1470. If you live in a condo or an HOA, you're a board member, you'd like to ask our attorney, Robert K. with K. Bender Rimbaum, if you have a question for him, please give us a call at 888-565-1470. And Robert, I want to go to tell people about your firm. And if you would this time, do a follow-up about, because I know how much services to your customers. So let's tell them about your firm as well as your customer service.
Sure. K. Bender Rembam has been providing legal services and community association law for about 30 years, started in 1992, and continuously has been providing these types of services started here in the Fort Lauderdale area. We're currently in Pompano Beach, have an office in Palm Beach Gardens and in Tampa, Florida. And through those offices, we provide these services pretty much throughout the state of Florida. We may not get all the way up to the northern part, but I'd say we cover the vast majority of the state. anything that an association may need for their legal services, be it review of the covenants, interpretations of the rights and liabilities of the association and the unit owners, negotiating contracts, addressing contract disputes, addressing violations by unit owners, collecting unpaid assessments, bankruptcy issues, all aspects of any form of issue that comes before a community association is what we do with our clients. We have state board certified attorneys in all of our offices that handle the day-to-day work for association work. And from the customer service perspective that you identify, that is the foundation of the services that we have always provided. Fast turnaround, efficient, being expressed in a way that's understandable to the layperson, so you don't need somebody to translate whatever the opinion you receive is. Those are what we strive to accomplish in all the matters that we handle for our association clients.
Well, I know if just by the times I've been at your office, there's always 2 or 3 people working at the front desk, so I know how important customer service is to you. I'm going to try to
live bodies answering the phones.
That's right. I'm going to try to stay on schedule tonight. We're going to go to break, and when we come back, we've got so much information for you. We do have a line open if you have a question for Robert. 888-565-1470. 888-565-1470. If you live in a condo or a HOA, you're a board member and you have a question for attorney Robert Kay, please give us a call. We'll be right back.
K. Bender Rembaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rembaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rembaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rembaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We are back. This is the Ask the Expert show. We're on every Thursday night from 6 to 7. We have South Florida's finest lawyers, doctors, financial, and home improvement. The first Thursday of the month is always for K. Bender Rembaum. I guess let's do you've got a schedule for this month.
Yes, October's a busy month. So.
Okay.
Yeah, there's a lot going on in October. Starting with October the 12th, there's 2 things going on that, actually 3. There's a expo at the Miami Beach Convention Center, at which we'll have a booth, and we're doing 2 programs, funding construction projects at 10 a.m. and the 2022 legal update at 2:30 p.m. That's at the Miami Beach Convention Center on October the 12th. Also on October the 12th, we have a Zoom webinar, the screening process, developing procedures and training committees. That'll be instructed by Andrew Black, and it's hosted by Vesta Property Services at 1 p.m. on October the 12th. On October the 14th, there's going to be the Palm Beach Expo at the Palm Beach Convention Center. And we'll have those same 2 programs at 10 a.m. funding construction projects, and the 2022 legal update at 2:45 p.m., so a little bit later in Palm Beach. That's on Thursday the 14th. On October the 20th at 7:30 a.m. in person at the Palm Beach International Airport Hilton, Peter Mullengarden of our Palm Beach Gardens office will be providing the 2022 legal update in person. There are continuing education credits for this, and it's hosted by the TSK Group, and that would be October 20th, 7:30 a.m. to 10 p.m. October the 21st at 12 noon to 1:30, there will be a webinar that Attorney Sean Brown from our Tampa office will be participating in a panel discussion called the Florida Condominium Education Initiative, the Election Process. There's an app for that. That's at 12 noon to 1:30 p.m. And there will be others participating, other lawyers, the condominium ombudsman, and it's hosted by the Florida Department of Business and Professional Regulation. October 21st, 12 noon. October 22nd at 10:30 a.m. to 12:30, we're doing a Zoom of the Condominium Association Board Member Certification. Danielle Brennan of our Palm Beach Gardens office will be hosting that at 10:30 on October the 22nd, certification for new and existing board members. And October 28th, we're going to do elections, condominiums, homeowners, and cooperative association at 10:30 a.m. to 11:30 a.m., also via Zoom, instructed by Allison Hertz from our Palm Beach Gardens office. That's another Zoom one. And then on November the 1st at 1 p.m., we're going to do a condominium and homeowners association board member certification, a combined presentation from 1 o'clock to 3 o'clock. Andrew Black will be providing that in conjunction with the city of Tamarack, but that will be a Zoom seminar. So that's what we've got. On October the 28th, I don't want to miss this one, there's a Tampa Expo at the Tampa Convention Center, at which we'll be presenting the 2022 legal update at 2:30. So those are the upcoming events for October through November the 1st. You can find all these on our website at kbrlegal.com. Go to the calendar, look for upcoming events, click on the event you're interested in, and do register so that you can receive the information so that you can participate in through the Zoom.
Wow, you got a busy month.
We do have a busy month.
We're getting close to the holidays. So tell me something, with the pandemic still going on, do you still get a lot of calls from your clients regarding what they can do and what they can't do? Or is that starting to die down now?
Well, I think that everybody, for the most part, understands what they need to do or should be doing. I think we've been going through this long enough that people are fairly comfortable with what limitations there may be. And since there are no state limitations anymore, it's going to be pretty much up to the community as to what they put in place. Generally speaking, the main issue that's still difficult for a lot of communities to be addressing is that this is coming into the meeting season. There are annual elections, and that usually starts in October and goes through April, is the busiest time of year for that. And when people aren't gathering and meeting together, that becomes a little bit more complicated for them. But there are ways to work through that.
Well, we had a board full of calls when we started. Our first call was a little long-winded. That's okay. We like calls like that, and people got tired of waiting. But we've also got so many emails, your emails that you write us, that you take the time to write questions that you have for Robert. So let me go. If you'd like to give us a call, the number here is 888-565-1470. That's 888-565-1470. The first email is from Katie in Palm Beach. She took your certification course, and she loves your show. How about my show? Why is it just Robert's show? No, she said, I love your show. She's on the condo board. She says her president wants to do everything his way. The owners are complaining and nothing is discussed. Most of the issues are about painting. And they've got 9 board members, and apparently the president does not ever consult with them. Should the president be consulting with the board?
Well, certainly, the president does not have absolute authority to run the community. The president is, while being the chief executive officer and the primary officer of the association, the president is supposed to be carrying out the functions that the board lay out for the president to accomplish. The board sets the policy for the association on all issues, and the president is the primary person to direct them carrying out. So the president isn't somebody who just does whatever they want. In communities where that is happening, that's because a majority of the board allows it to happen. So if the board is not happy with the president's behavior, a majority of the board can change the president at any time. They have full authority to change the officers at their discretion whenever they feel like it. And there doesn't have to be a reason stated. They can just make the change by a majority vote of the board that's present at a meeting that has a quorum in attendance. So for a 9-member board, if 5 people are there, 3 of them can change the president. Obviously, if all 9 of them are there, it'll take a vote of 5 of them. And they need somebody who will be willing to do the job, of course. If the majority of the board doesn't mind the president doing what they're doing, but the owners are unhappy with that, then the owners have to make their changes by their voting, either at the annual election or through the recall process. And the recall process can be done anytime during the year except for 60 days before the election, 60 days after. So that 120-day period that surrounds the election is not recall time. So you have to time your recall relative to that.
Okay, here's a board member, Ben, in Doral. I don't think we've ever had a call from Doral, but
no, we get calls from Doral all the time.
You get calls from Doral all the time.
We do.
He heard that there's going to be a lot of changes regarding reserves and inspections. Is that true?
Well, whether there's going to be a lot of changes is hard to predict, but I'm sure there's going to be some changes. Some are being drafted and prepared for the upcoming legislative session, which doesn't start until January, and it goes for 2 months in the early part of next year. So there's not going to be any changes between now and then, but now is the time that the legislators are preparing the bills that they're going to be presenting, and all the lobbying's going on and working out to get the language the way they want. There are some studies that are ongoing throughout the state as to what exactly they're going to be suggesting be changed for inspection requirements, for reserve mandates or reserve limitations, or the ability of the owners to waive them, and how that's going to be changed, if at all. So it's still a little early in the game to predict exactly what's going to happen. We're just anticipating that there'll certainly be something.
Okay, let's go back to the phones. Tracy in Kings Point. I've heard of Kings Point. Hi, Tracy.
Hi, how you doing?
We're doing good. You have a question for
Great.
Robert?
I have a question for Robert. Yeah.
Go ahead, Tracy.
Hello?
Go ahead, Tracy.
We have a woman who likes to sunbathe on the front lawn, and our rules and regulations don't specifically specify that. So we're looking to change our rules just a bit to include something about sunning themselves on the lawn, sunbathing, loitering on the lawn, and something to that degree. And I was wondering what the procedure is to amend rules.
Well, for the most part, boards of directors are given the authority in your declarations of condominium or covenants to adopt certain rules and regulations that govern the use of common properties, and some often within the units or the lots of a homeowner association. Some of the communities, it was more common for those that were created in the early through middle 70s, contain provisions that call for unit owner approval of board-made rules, and often it's as high as 75% owner approval requirement. So you need to check your documents to see whether or not yours are one that allows the board to make rules on its own. If the board is making such a rule, then it just has to include that rule is going to be considered in its agenda for its posted notice for its board meeting, and then it would do so at a meeting at which a quorum of the board is present. And if it's a rule that's governing the use of the unit in a condominium or homeowner association, then there needs to be a 14-day notice that indicates that there's going to be a rule governing the use of the residential unit. So that's the general procedure. Now, when you're talking about a rule that limits the ability of a resident to sunbathe on the grass, there is a standards for whether rules will be enforceable that the courts have fashioned over the years. Basically a 3-level test. One, the board has to have the authority to make such a rule. Assuming it does, the rule cannot be in conflict with something that's expressed in your existing documents, either absolutely expressed or reasonably inferred. And when we say reasonably inferred, if something is silent, the inference is it's not restricted, so then you couldn't make a rule. For instance, if there's nothing about animal restrictions in your documents, you can't make a rule that says no pets. And then the last hurdle that the board has to cross on such a rule is it has to be reasonable in its application and on its face. Now, from what you've said, whether or not a rule that limits somebody's ability to sunbathe on the lawn is reasonable is something that could be open to challenge. So that's something only a court of law could ultimately decide upon. And that's the one point of caution that I would have for a rule like that. So it has to be fashioned in such a way that you're going to consider it reasonable once it's in place.
Hey, Tracy.
That's terrific. Thank you so much.
Tracy,
Yes.
you know what would be worse is if I was out there sunbathing on the grass. So
I'm not so sure that's true.
thank you, Tracy.
Thank you again.
So,
Thanks for listening.
Robert, you know this when the the towers came down in Surfside, I've noticed a lot more people that are writing in or asking about insurance. Because from what I understand, as of right now, there's about $2 million to be split up between 140 units. And I'm so glad I don't have to be that person who decides who gets what. It's not a lot of money.
Well, I did hear something about the land being sold for $120 million. So I don't think that's finalized yet, but that might help. Although there's probably lenders involved that have mortgages that's going to go first. But yeah, $2 million of insurance for a whole building doesn't sound like a lot or anywhere close to enough.
The reason I brought it up is I got several questions like this. Why are there no laws to make it mandatory that you have condo insurance? Is that really true?
Well, it depends on what the writer means by condo insurance. There is a requirement for the association to have adequate insurance of all of the portions of the condominium that the association is required to insure. And then there's a carve out of portions that the unit owner is supposed to insure. And that's not a mandatory requirement. It's just the unit owner's responsible. And if they choose to have insurance, then they get an insurance policy. If they don't want to buy an insurance policy, they're still responsible for whatever happens to these items. You know, that's wall, floor, and ceiling coverings, cabinetry, and personal property, and things of that nature could fall to the unit owner to have to maintain or insure or replace at their own cost if they don't have insurance. There was a time when they threw in a requirement for a unit owner to maintain insurance, and if they didn't, the association could place it and charge them for it. The problem was that no insurance providers would sell anything to associations because they didn't consider their interest sufficient to allow them to purchase insurance. So that was taken out of the statute, and it currently isn't in there. But the association itself is required to maintain adequate insurance, and there's a law, and this is a section of the statute that's been amended probably 30 times since I've started working in this area of the law. So it's highly amended over the years, and the association has a very large portion of condominiums it's obligated to insure. And if they only had $2 million of coverage on that building, they likely violated the statutory requirement of having adequate insurance, because that is clearly not adequate.
Well, here's a question. This is kind of a follow-up from Susan in Hollywood. How do I get our board to stop kicking repairs down the road, especially after the tragedy at Surfside?
Well, unfortunately, no one unit owner can likely get the board to do anything. It takes a group effort of the unit owners to pool their power, as it were, and their power primarily is who serves on the board. And they can control that through the election and the recall process, as we discussed earlier. And that's their primary strength in getting the board to do what they want them to do. Otherwise, you need to have like-minded people serving in those positions to get things done. The big problem, which we have read about because of what happened down in Surfside, is that things are very expensive, and boards are reluctant, if not totally unwilling, to get into contracts that's going to subject their owners to large assessments into the millions of dollars as are necessary to do the repairs that are needed. That's compounded by the fact that owners have routinely through the years completely waived or mostly waived reserves and don't have a sufficient amount of reserves in place to meet the needs, thinking that, well, when we need it, we'll have a special assessment, or I won't be here then, someone else will have that problem. That's been the mindset through the years, and perhaps this tragedy could be a wake-up call to help people start to think differently. But unfortunately, the only way to get a board to do what's necessary is get the right people in place to serve on that board.
Okay. Here's again, kind of a insurance question, kind of from the tragedy that happened. This is from Sam in Boynton. He said, after what happened in Surfside, how should our condo association run our business, especially when it comes to reserves and safety issues? Do you think we should bring back the 5-year inspection rule? And should we get a structural engineer?
Well, certainly they have the ability, regardless of what the law is, to involve their building in routine and regular inspections, whether the statute requires it or not. And certainly a structural engineer will be necessary, or someone of a similar qualifications to best give them the advice they need as to the conditions of the property. It doesn't require there to be a legislative mandate from Tallahassee to take care of your buildings, to know they need to be taken care of. The documents obligate the association to maintain all of the common elements, and boards should be thinking in those terms, regardless of whether there's a minimum requirement in the statute. We know that the elements in this part of the world are fairly corrosive to building materials that humans make. So it's important to be vigilant all the time and make sure that your buildings are in as tip-top condition as you can get them.
Remember at the beginning of the show, I was talking about we get people who write in that say they feel so more educated from listening to your show. Here's actually one of them saying how much he loves your show. And he said, due to your show, I feel armed, which I don't know what that means, and educated when I talk to my board. But he wants to know, how do I get my community to be more transparent?
Well, transparency in the operation of community associations is something that's already written in the law. Boards are required to hold their meetings in front of owners with proper notice. All of the official records of the association are open to the inspection and copying by any owner that makes a written request for that to take place. And I think that it's certainly something that owners have to take upon themselves to involve themselves in the operations of their association. It's not an easy task. It's something that more often than not, individuals think, well, just let somebody else do it. They're handling it, so I don't have to think about it. And that's what leads to bigger problems. Involvement by the owners, come to meetings, be aware of what's going on, be up to date with what's in the records, and be involved. That's the best way to achieve the goal that this writer has asked.
Okay. Here's somebody who's putting a new roof on, and our condos have asked all the owners to take their shutters down, but they won't cooperate. What can we do?
That's going to depend on what their documents have and who's responsible for what when it comes to the shutters. In the situation where owners put up their own shutters and are responsible for them, if they're refusing to take them down, it may be necessary to involve the association attorney and possibly involve the courts in getting an order from the court, which will delay the process of whatever project is being undertaken. But typically, threats from the lawyer of potential litigation often get the cooperation that they're looking for. In some instances, the association has the ability to do self-help and remove it themselves and charge it to the owners, but that's not the ideal approach to take and could lead to certain problems and possible violence that you don't want to necessarily have to deal with in a community. So legal approach is the preferred one. This should all be something that boards are thinking about in the contracting process with the whatever provider that they're dealing with on the project, and to be aware of the situation and address it in the contract and deal with the owners ahead of time. It's best not to wait till the middle of the project to have to address that.
We just got 2 texts in. One of them wants to know, they says, we have tennis courts, but they're hardly ever used. we would like to convert them, some of the courts, to pickleball. I don't even know what pickleball is, but what do they have to do?
It's all the rage. Pickleball is all the rage throughout the country. Fastest growing sport in America.
Is it really?
It's like tennis. It's described as like tennis and ping pong combined, but it's on a similar size court, not quite as large. Depending on whether it's an HOA or a condominium, that's going to depend on the answer. The documents have to be reviewed to see whether or not an alteration of a common area is something that the association can do or not do without a vote of the owners or with the vote of the owners. So unfortunately, more information is needed to fully answer that question. If it's a condominium and the statute says that there can't be a material alteration or a substantial improvement except as provided in the documents. And if the documents are silent, then a 75% vote of the owners. Usually the documents will have something in there to say how it works. Sometimes it just says what the statute does. Sometimes it's tied to a dollar figure. Sometimes it's a percentage of their budget. Sometimes it just says the board can do it. So you want to check your documents and see how it addresses on that. There is no statute for homeowner associations, so it's strictly what your documents say.
Okay. We're going to go to our last break. I've got another question that was texted in. I'll ask you on the other side. Give everybody your phone number.
You can reach us at 800-974-0680 or write to us at info@kbrlegal.com. Or go to the website, kbrlegal.com. There's a contact form you can fill out. We can get back to you that way.
Yeah, and I got to tell people, you've got the finest website. It's got so much great information on there that you can use it for many different things. Let's go to break. When we come back, we'll go to the phone, and I want to get to this text that someone wrote us. We'll be right back. We're with K. Bender Rimbaum, attorney Robert K. We'll be right back.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida, with offices in Pompano Beach, Palm Beach Gardens, Tampa, as well as in Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law, and they assist clients with all matters of community association legal issues while keeping them up to date on new developments affecting their associations. K. Bender Rimbaum is also a well-known provider of free legal education, which often includes CE credit for managers and state certifications for board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or just write to them via email at info@kbrlegal.com.
We're back. This is the Ask the Expert Show. We're on every Thursday night from 6 to 7 drive time. And the first Thursday of the month, we always have our community association law firm, K. Bender Rimbaum. Let's go to the phone. Let's go to Jeff in Boynton Beach. Hi,
Good
Jeff.
evening. How are you guys? Hi. Great show as always. I just wanted to. This is a little different. Not really a question, but a comment. Because when the person touched upon the pickleball thing, it just spawned a memory from my career in management. So if that person is listening, we had a battle at our condominium between the pickleball people and the tennis people. You know, they don't want to give up the courts, and pickleball had nowhere to go. So what we ended up doing was a really cool compromise, and we took a couple of the tennis courts and had the tennis boundaries in one color and pickleball boundaries in another color, and they shared some of the same courts, and it made everybody happy. They just had designated hours and time. So I just wanted to throw that in there. I thought that might be something people would be interested in as a potential solution. That's all.
I'm going to have to Google
Jeff,
this tonight.
That's a good idea. And when they do that, I think they wouldn't be running into the issue of material alteration, because all they're doing is just putting markings on the court. So everything remains the same. So that's a good solution.
Well, there you go. And keep up the great work, guys. I'm thrilled to be listening once again. I'm looking forward to next month already.
Thank you.
Thanks for listening.
All right, good night.
So,
thank you.
Robert, we had, and I remember this guy's question. I guess he wanted to make sure. He kind of gave me the short version. If you have to fine an owner, let's say $1,000, and they still don't correct it, can you fine them another $1,000? If they continue doing the same thing?
Fining is different for condominiums and homeowners associations.
Okay, so did not say which one it was.
Which this is. But generally speaking, for condominiums, fining is more specific and limited, and the maximum can be $1,000. Homeowner association, the statute allows the documents to provide for a higher amount, but if the documents do not, then it limits it to $1,000 on the specific violation. So the real point to remember is that fines are supposed to be an assistance to deter certain conduct that's a violation, but if the violation continues after the fine, then you should move on to the next level of enforcement, and that would be through the attorney and into the court system if necessary, so as to resolve the actual issue, as opposed to racking up fines that nobody's paying.
Okay, we just got another text. This is I guess a board member. Can you go over what your schedule is for this month? Do you mind doing that?
No, of course not. October the 12th, we have two things going on. There's a expo in Miami, which we have two seminars, and one in the morning at 10 o'clock, funding construction projects, and at 2:30, the 2022 legal update. That's at the Miami Beach Convention Center on October the 12th. We also have on October the 12th at 1 o'clock, a Zoom seminar, The Screening Process, Developing Procedures and Training Committees on the Sale and Lease Approval Process. Andrew Black will be teaching that, hosted by Vesta Property Services, 1 o'clock on October the 12th for an hour. October 14th, there's a Palm Beach expo at the Palm Beach Convention Center. We'll have the same two courses. At 10 o'clock is the funding construction projects, and at 2:45 is the 2022 legal update. That's at the Palm Beach County Convention Center on October the 14th. October 20th, 7:30 in the morning, in person at the Palm Beach International Airport, Hilton. A 2022 legal update by Peter Mullengarden, hosted by the TSK Group. There's continuing education for that as well. October 21st, there's going to be a panel discussion hosted by the Florida Department of Business and Professional Regulation at 12 noon. Florida Condominium Education Initiative, the election process. There's an app for that, and that's via GoToWebinar. That's at 12 noon on October 21st. Sean Brown will be participating in that from K-Bender. October 22nd, Condominium Association Board Member Certification at 10:30 in the morning till 12:30. Danielle Brennan will be teaching via Zoom, 10:30 October 22nd. October 28th at 10:30 to 11:30, elections, condominium, HOAs, and cooperatives taught by Allison Hertz, also via Zoom, 10:30 to 11:30 on October 28th. Last October 28th, there's also the Tampa Expo at the Tampa Convention Center. We'll be providing the 2022 legal update at 2:30 p.m. there. And then on November the 1st, condominium and homeowner association board member certification, a combined class from 1 o'clock to 3 o'clock, hosted by the City of Tamarack. Andrew Black will be the instructor there. All of these are identified on our website, kbrlegal.com, on the calendar, and then you find the event you're interested in, click on it to register.
Okay, this is an interesting text we just got. Our property does have a law firm that represents us. Are we allowed to talk to another firm for a second opinion?
The answer to that is yes. No attorney has an exclusive agreement with any client. The client is always free to bring in as many attorneys as they feel the need to do, as long as they're willing to pay for them. And certainly second opinions are something that they're free to do and they might like better.
Well, I know one thing for sure after doing the show with you for so long, that it might not be within the hour or maybe not even the same day, depending on what time they call, but you get back with everybody. You don't leave anybody hanging out there. And that's not always the norm from everything I read out there about.
No, many of our new clients come here because they can't get an answer from their attorneys. It's taking weeks into months to get an answer to relatively simple questions. We reply to all of our inquiries, our telephone calls, our emails, the same day or no later than the day following to take care of, at least to make the contact. If it's going to take a little longer because there's a lot more involved in what is being asked, that might happen, but you're not going to be wondering, did they get it? Are we in process? What's going on? So we are always in communication with our clients as they reach out to us.
Well, I know you're busy enough with your own clients, but I've been amazed since I've been doing the show with you that what you do is not the norm, that there are properties out there that have firms that they're really upset with because they don't get back with them right away. Sometimes they say it's weeks before they get back with them.
That is a common problem. That's another one of the foundations of our firm, is that prompt and responsiveness is what is required of all of the employees.
Well, we've got 2 more minutes, and I would love for you to tell people out there why they should retain your firm. And you can brag.
I think the primary reasons to use a firm, K. Bender Rembaum, is that we have the experience among all of our offices and the attorneys that are in them, most of which are board certified by the Florida Bar, of which there's only around 200 in the whole state. We happen to have 9 or 10 of them, and that makes us specialists in the area. We have been involved in this field for over 30 years myself, and almost as much for most of the other attorneys that are here working for our clients. We do have some newer ones, of course, but we do supervise them very carefully to make sure that we're all on the same page in the advice we provide to our clients. We're responsive, we're efficient, we're cost effective, and we're good to work with. Those are all good reasons.
Those are very good reasons. Give everybody your phone number before we go.
You can reach any of our offices at 800-974-0680. You can reach us at info@kbrlegal.com. You can go to our website, kbrlegal.com, and fill out the contact form on the first page, and someone will get back to you within a day. Also on our website, you'll find resources. We have Rembaum's Community Roundup, and we have Association Roundup, and we have Legal Morsels, our articles of topical interest to board members across the scheme of what we do. So check us out.
I love having you on the show. We appreciate everybody's participation tonight. We'll be back next Thursday with more Ask the Experts. Have a
I'll
good
see you
weekend,
next month.
everybody. See you next month, Robert.
Thank you for tuning in today to Ask the Experts, sponsored by board-certified family law attorney Tina Lort of Lort Law, LLC. Join host Steve-O again next Thursday for more interviews with the top experts in South Florida in the areas of legal, health, financial, and home improvement on Ask the Experts.
The opinions expressed on the preceding sponsored